Owner of land adjacent to rezoned property may have standing to challenge rezoning through declaratory judgment action, even when adjacent property is outside of municipality that adopted rezoning. Matthew E. Moore et al. V. City of Middletown et al. Case number 2010-1363, 12th District Court of Appeals, Butler County.
But it's not clear to me where your clients live in relation to the property that was rezoned by Middletown.
Within 10 feet.
Right across the road? So they're
right there.
They bump up against it. They're an adjoining property owner.
And this is their residence. They're not planning to use it for commercial purposes, right?
That's correct,
Which
Your
gets
Honor.
into the argument about whether the Ohio Constitution protects personal property rights to a greater extent than the United States Constitution.
That's correct, Your Honor. We're still dealing with hundreds of thousands of tons of particulate matter being dumped on the surrounding properties. There's not a whole lot you can do when you have to superheat coal in order to make steel.
How can the city of Middletown take property outside its jurisdiction? That's my question here. The remedy, as counsel for the previous case was talking about, the remedy generally is mandamus, to have the governmental unit then partially take the property, provide compensation. But you have someone who is not a resident of the jurisdiction.
If in fact this parade of horribles that the appellants talk about were to occur, they do have a remedy. The remedy is against the party that actually does those things. That would be the Coke plant. You would have a trespass action. You would have a nuisance action. So that, and if you look at our case, and where I would say with respect to the appellant's argument, we have a Coke plant that isn't even up and running yet.
Shouldn't the city be taking something into consideration like that instead of saying we're going to help to create a problem for the surrounding landowners, and then we're going to let the victims of our municipal action fight their own battle?
I think, Your Honor, if that's how you phrase it, I think the answer is yes, and I think they did. You have, before these plant, like this plant, for example, can be manufactured and put into operation, you have the EPA regulations. You have all sorts of regulations that have to be met, all sorts of requirements that have to be met before they're allowed to actually start operating a plant.
On August 30th, 2012, the Supreme Court of Ohio ruled that owner of property that is outside of a municipality but is adjacent to property rezoned by that municipality may pursue a declaratory judgment action to challenge the constitutionality of the rezoning if the owner pleads that he has suffered an injury caused by the rezoning that is likely to be redressed. Applying that analysis to a Butler County case, the court partially reversed a decision of the 12th District Court of Appeals and remanded for further proceedings a declaratory judgment action filed by Lori and Matthew Moore of Monroe against the city of Middletown. The Moore suit challenges the constitutionality of two Middletown city ordinances that rezoned a parcel of land adjacent to the Moore's property from low-density residential to general industrial use. In a 4-3 majority opinion authored by Chief Justice Maureen O'Connor, the court affirmed the 12th District's holding that because the Moore's property is outside of Middletown, they do not have legal standing to pursue a mandamus action to compel Middletown to appropriate their land and compensate them for it. However, the court rejected the 12th District's holding that the Moore's status as non-residents of Middletown also barred them from pursuing a declaratory judgment that the city's rezoning ordinance violated the due process and equal protection clauses of the U.S. and Ohio constitutions and is therefore void.